you, but after I want her. No, because someone's already sitting there.
Here?
Who's the name tag? Yes.
She is the deputy.
Open the Committee of Children and Family Law. This is April 15th, 2025. I hope your taxes are in. And we have some guests here today. Representative Bernardi in for Representative Rice, Representative Petronell in for Vice Chair DeSimone. Representative Fox in for Amy Malone, and Colonel Chris Schultz in for Gabby Grossman. And the way I like to run the committee meetings when we have substitutes is to turn you guys loose. That doesn't mean wandering around. What that means is some chairs will want you just to keep your mouth shut until it's time to vote. All my experiences being a substitute, I could never pull that off, so why should anybody else? You bring wisdom from your backgrounds, from your committees, and I want to hear it. I want you to ask questions and participate and things like that. For the record, I'm Mr. Chairman, not Mr. Chair. Mr. Chairman is sitting in Mr. Chair, and that's my pronoun, so Mr. Chairman. Okay, open the hearing now on Senate Bill 269, removing references to matrimonial age and time waivers in the Vital Records Act. And of all the senators who are signed on to this, I don't see any. I do see a few members of our committee, so I'm going to go out on a limb and guess that Representative Petrino is going to introduce this.
Well, good morning, Mr. Chairman and members of the committee. I'm Representative Peter Petrino, serving here on the Children and Family Law Committee, and I am pleased to introduce Senate Bill 269 on behalf of Senator Deborah Altshuler, who is not here to take any questions. And
You
that's
are
it.
a co-sponsor.
I am a co-sponsor,
Will you take any questions?
as best as I can.
That's all we ask.
Okay.
Now we have to have some questions.
As far as I see this bill, it looks to me that basically what we're doing is replacing the term bride and groom to applicants in the statute. And that is as far as my understanding of this legislation goes.
I see an age restriction down here. Yes, Representative Seidel.
I do have a question, Mr. Chairman.
A question?
Yes.
You may ask your question.
Thank you, Mr. Chairman. And thank you for taking my question.
Yeah.
I'm just curious, what is the need for changing bride and groom to applicants instead?
Well, I think the answer to that is pretty obvious. We now have same-sex marriage in New Hampshire, and some individuals who are getting married do not see themselves as brides or necessarily as grooms. And so putting applicant just takes away the gender references, the traditional gender references that we have to male and females.
Representative Bernardi.
Thank you, Mr. Chairman. I had a similar question, but I also have questions about the when I read this that this had been asked for by the Secretary of State. Is that indeed the genesis of this or not?
I have no knowledge of that.
Thank you, Mr. Chairman. So this isn't a question, but I do have knowledge of this. This has been by the Secretary of State. So as we have modernized language across the United States, there's a need federally for it to be more standard. And so the standard has now become applicants instead of bride and groom. So it's more of a gender neutral kind of situation.
Did I hear at the beginning of your answer that this was requested by the Secretary of State?
That's what I've heard, yes.
Okay. I see at the bottom there is language about age and residence, and can you speak to that?
No, I'm not specifically sure what the reason was for crossing that out. We, of course, do have the minimum age of 18, and that is identified here. So, no.
It basically makes what we do standard irrespective of previous geography, seems to me. Representative Raymond,
Thank you. Mine is just a would you believe question. And would you believe that this passed the
you
Senate?
know I love those.
I know. I love them too
you're
sometimes.
welcome.
Would you believe that this passed the Senate Child and Family Law unanimously and then was an 18-0 in the Senate as well?
That is correct.
Thank you.
You would believe that?
Yes, I do.
Okay. I'm blanking the name, I'm sorry. Just like last time? Yeah, okay.
Same person I was 2 seconds ago, although sometimes that
Yeah,
changes.
but I didn't call you by name then.
No, thank you, Mr. Chairman. So this is, I guess I should say, would you believe that this really is truly more of an update from the Secretary of State as far as more of a housekeeping bill and also keeping our language very concise. That's why you see, if you look at that last paragraph, we're not really changing the meaning. We're making the language much more concise, which is what we always like to do in legislation, in theory.
Representative Schultz.
Thank you, Mr. Chair. So my spouse and I went by, I was the bride, he was the groom. Does this bill change, and I got married in a church, does this bill change that?
No, not at all. No, this is just for statute to identify applicants as opposed to bride and groom. But traditionally, what folks do on their own, all right, surmise that's always the case. You know, when you're getting married, the officiant is not going to say, I now pronounce you applicant and applicant.
Oh, that's good. Anyone else? Let me ask my Republicans here. We did not have our caucus last night. Do any of the Republicans here see the need to have a caucus before we vote on this? Okay, I see. Yes. Okay. So I am going to. What?
I'm sorry, Mr. Chair. I just wanted to clarify a little bit for the language. Just to call applicant is just not going to be for everybody, just the people who wanted to call them applicant.
The statute would refer to individuals who are applying to get married as applicants, as opposed to the traditional, the bride and the groom.
Yeah.
And it's just for a matter of clarification in the existing statute. Since we do have same-sex marriages, we're no longer going to be referred to the traditional gender terminology, but just to have it neutral and say that those who are intending to get married are the applicants, be they two men, be they two women, be they a man or a woman. And that just brings us up to date in terms of our current statutes. But on your own, you can do as you will. As I was answering Representative Schultz's question, traditionally, people are still free to refer to themselves as brides and grooms.
As I read this language in the light of my growing legal education, I can see that applicants is not necessarily two people. Does this open the door for threesomes and what have yous?
I believe that the current statute does provide for two individuals, two adult human beings to get married. And I'm kind of amused sitting here answering these questions, to be honest, as I'm not the prime sponsor, but doing the best I can. I do believe that this is pretty straightforward common sense.
Follow-up question, do you believe that Senator Altshuler owes you big now?
Yes, I do.
I'll sign off on that. All right, I see that a couple of my Republicans have signified they would like to talk it over as a caucus. So, Mr. Ranking Member, if you could take your troops to an empty room and do whatever you wish to do, including having a
Absolutely.
caucus,
Absolutely.
and we'll come and get you. Thank you. Yes.
I just wanted to note really quick that this would not supersede New Hampshire's law against polygamy. So we're in good shape. It's just two people.
Thank you. It was an episode on Elspeth a week ago, so that's fresh in my mind. Isn't that fun? I like that shit. Yeah. Do you carry a number of bags with you? Oh, my hero.
Maybe she's Colonel.
This is now a closed Republican caucus. Everyone else needs to leave the room. Thank you. And any recordings need to be turned off. Thank you. Representative Markell, you brought up an interesting point that I think is worthy of being shared.
Okay. Yes, thank you, Mr. Chairman. Yeah, as a practicing family law attorney.
Could you make the mic stand closer to you,
Oh,
please?
I'm sorry. Yes,
Thank
sir.
you. We're still talking beforehand.
Okay. As a practicing family law attorney, I noticed this information is substantially similar to the vital statistics forms that are required to be filed at some point during the divorce process. Okay. Ordinarily, good practice is they are filed with the petitioner who drafts the vital statistic form, and that's typically the practice. The vital statistics form, which I think you can find probably on the Judicial Branch website, indicates pretty much all of this information is already there. Okay, and it also delineates, okay, the applicant. Well, it would be the applicant, but it's person A and person B. So, I mean, I just view this as redundant, and I just don't see it as necessary.
Would that be perhaps the reason the title of this bill has nothing to do with gender, but has to do with matrimonial age and time waivers in the Vital Records Act?
Yeah, I mean, I don't know why you would need a time waiver. I just don't know why you need it. The other thing that it could have a potential implication for, now that I think about it, has to do with our present alimony statute. One of the things that I think people should be aware of is that the alimony statute, I was involved in the reform movement back in like 2017-18. And they also involve the date of the service of petition from the date of the marriage, okay, when they want to measure the potential length for alimony. And I don't understand why you would want to do this. It may at some point conflict with it and may make alimony a little bit more problematical. I'm not stating that as an absolute fact, but it's something I think you should look at. So in sum, I just don't see where this piece of legislation is needed.
Representative Petrino.
Thank you, Mr. Chairman. I just have a question. I want to understand, if I understand you correctly, you're saying that this is not necessary because the matter is already addressed in other aspects of law?
Correct. In
Okay.
other words, the judicial branch has substantially addressed this information.
Okay, so in that regard, so wouldn't it be wise then to have our statutes conform with that so there is consistency, so you don't have conflict? Because when I heard what you had to say in terms of your explanation was that potentially, probably, maybe somewhere down the road, this could be an issue, but not right now, so we really don't
Well,
need it?
only if you were, only in a tangential sense. For example, if the date of the marriage comes up, and we already have certificates, you know,
Okay.
I think it's, don't quote me, but I think it's RSA 157 at SEC, which deals with the marriage, which deals with marriage and timing. And I think if I remember correctly, off the top of my head, I think you're issued a marriage license, which gives you roughly 90 days to be able to execute whether or not you're going forward with the marriage or not. And the other thing is, in the event that something along of either a marriage, which is either voidable or void ab initio, okay, comes up and becomes a petition for annulment, or in the extreme sense, bigamous, this doesn't help you one way or the other.
I just want a quick question. Sure, go ahead. Okay, thank you. So what I heard you say was only if, and only if tells me that there is a probability. And even if there is a minuscule probability, I believe that it would make sense to have all of our statutes conform. So I really do not see the harm in this very simple change, if this change would then have us in conformity with all of our other statutes. And again, going back to your words, only if, which implies that there could be a problem. So once again, having consistency, from my point of view, makes sense.
Okay, well, once again, this is a form that's already existing, okay? I don't think it adds anything, and the form, it's I don't know what harm are you expect to catch with it? What harm are you preventing?
And likewise, what harm would it be to change the wording for the sake of, I mean, your consistency? I mean, your rationale doesn't make any sense. Why not change it then?
Well, I guess what I'm saying here is whether it's necessary. If you look at, in terms of whether it's needed.
Thank you, Mr. Chairman. So my question, I have a few different questions. So one, are you saying that this entire thing is unnecessary, this entire statute, or just updating the statute is unnecessary?
Well, what I'm saying here is that when we look at time waivers remove, okay, shall complete the following statistics. Okay, and so if you're changing the words bride and groom to applicants, I mean, I understand I understand the housekeeping aspect of it. Okay, you know, you're changing it to applicant. So I suppose if you were to, if it's from a housekeeping standpoint, okay, in other words, you're worried about whether or not brides and grooms denote sex, and we already have, you know, same-sex marriage, which is allowed, okay, and I think by operation of law back around 2010, which, if I remember correctly, civil unions that were not dissolved by operation of law became marriages. You could, I don't know what it adds to anything. I'm certainly bride and groom. If what you're changing is applicants to bride and groom, okay, you could certainly, you could do that if you want. Outside of that, you know, I don't know if you need it.
Representative Gregg, follow up?
Yes, please. Thank you. So with all due respect, I know that you work in this space as a lawyer and stuff,
Right.
but this is the Secretary of State who works even much more intimately with this. I think also what we see a lot, especially with 400 legislators, is that we have a lot of legislation, including even, you know, I've been working in the mental health access space, stuff that is dated way back in the 80s that we're having to update so that it conforms to what this is. This particular language came before the Marriage Equality Act. So now that we have the Marriage Equality Act, it's important to make sure that there is consistency within our statutes in places like this. This is something that the Secretary of State noticed and said, you know what, this is not up to date. This is not uniform with what we have. So this is truly a we don't like to say truly housekeeping bills, but it really is a housekeeping bill in updating our statute to be consistent with what the laws of New Hampshire state. So that's why you would change this from bride and groom to applicants, because we recognize that sometimes there's a bride and bride, or sometimes there's a groom and groom. So it's important to update this to make that known.
Okay, one other question that I would have would be, how are the marriage licenses titled? Are they titled applicant, or are they titled man, woman, or are they titled potential spouse? How are they titled?
Well, I assume the Secretary of State would be making sure that those are also in a line. If he's paying attention and saying that we need to update this, I'm sure that he's on that, but that would be something that he's looking at.
Okay.
I'm a little concerned. Nobody from the Secretary of State's office showed up today. Somebody else, was it Representative Schultz, had your hand up?
I appreciate, Mr. Chair, that you give us subs a chance to speak. I mean, I'm thinking of this in my own experience. I didn't get married till I was 43. I'm now 54. I remember I picked up the form here at Concord City Clerk's office. I was very excited. My mom was like, oh my gosh, she's finally marrying an adult human. When I was younger, she really wanted, for decades, actually, she'd hoped I'd marry a Catholic. But by the time I got there, she was very happy that my spouse was a wonderful guy. Anyway, all this
As
to say,
opposed to a Catholic.
yeah, he had been baptized Catholic, but he is not Catholic. But she was just so thrilled that finally something. Come on, lady. I joke that I skipped my first marriage. You know, but the civil process is a civil bureaucratic process. I went and picked it up by myself at the clerk's office and was excited about it or whatever. But what was meaningful was the ceremony. And that form was signed not in the church. It was signed like in the vestibule that you know, and I took it back to the clerk's office. That's just the legal stuff. But all the religious stuff pertaining to my marriage and witnessing in front of my mother and all of that stuff with our priest was all inside the church. So I get that there are people who don't like that we have civil unions. I understand that. I can respect that. My religion isn't cool with that. It is what it is. But this is just about the bureaucrat stuff, you know, all the stuff that I know none of us like. It doesn't change what my religion thinks and feels about my marriage or my bridedom. So that's my 2 cents.
Mr. Chairman?
Thank you.
Yes, you were next. Representative Nelson, and then
Thank you, Mr. Chairman. Just for the record, I don't have a problem with same-sex marriage. I do have a problem with the fact that the prime sponsor was not here. Representative Petrino, you did a great job filling in. Thank you for that. I know being put on the spot is not easy. And I'm also very frustrated that we do not have a representative from the Secretary of State's office to give us clarity. I don't like to vote on a bill where we're making assumptions. We're assuming things here, and that's where my frustration lies. Thank you.
I thought I saw a hand over this away. Did I see a hand over this away? How about over that away? How about this?
Yes, Mr. Chairman, I was just
Oh,
addressing
yes.
a prior remark.
Yes, Representative.
Yes, civil unions no longer exist in the state of New Hampshire. That was a mid-step before that was to recognize unions of the same sex that didn't rise that didn't rise to the level of marriage. Marriage was treated differently then. Okay, as a separate issue from civil
That's
unions.
true.
Right. And so so in other words, basically it was kind of an interesting conundrum, because if you were same sex, you were able to get civil unioned. But prior to all the changes, married people couldn't do it. I mean, heterosexual couples weren't allowed to see you. You had to get married.
Yeah. Yeah, Representative Petrino.
Okay, thank you. I appreciate that. I have officiated a number of weddings, and I went back and I looked at some of the marriage certificates that I signed, and you're correct. It does say on it, person A is the groom and person B is the bride. And I'm just wondering, how do we move forward with same-sex marriage when, say, 2 men are getting married? Which one identifies themselves as the bride? The groom, and the same with the women. You know, which one identifies themselves as the bride and the groom? And we have Representative Raymond, who thinks she knows the answer to that.
Representative Raymond for the win.
Thank you, Mr. Chairman, and thank you, Rep. Patrigno. So New Hampshire State Law RSA 457 states, quote, "Marriage is the legally recognized union of 2 people.
It's 450.
Any person who otherwise meets the eligibility requirements of this chapter may marry any other eligible person regardless of gender. Each party to a marriage shall be designated bride, groom, or spouse." So spouse is the third option. But you can't put spouse in this part of the law, which is RSA 5C41, because you're not a spouse until you have completed the marriage ceremony.
Representative Nelson for the,
I think you're a bride up until you say I do, and then you become a spouse.
Sorry, thank you. Oh, I see. Okay, all right. Okay.
Representative Georges.
Thank you, Mr. Chairman. I just want the question.
Wait, hold on for a second here. I want them to be able to finish what they're doing here. That's okay.
I don't think
We got
so.
some time.
For me, it's not a big problem, because when the 2 people go to married, because there is can be they are the same sex married, the same sex, but they know who's a bride, who's a groom. I think so. They know that. I think so. They know that. They know who's a groom, who is a bride. It can be the same sex. I think so. They know that.
Representative Gregg.
Thank you, Mr. Chairman. As a matter of course, too, this feels like an exec session, but are we just deciding if we're going to exec it? And then I do have something else, but
Yeah.
Okay. So I don't think anybody here has stated they're against the Marriage Equality Act, which is, the law that we have currently. In looking at this, we can use our own matter of deduction and say, okay, well, a bride and groom, this makes this hard. Our marriage license is currently looking at bride and groom, yes, but there has to be a chicken and there has to be an egg. So if this makes sense, bride and groom to applicants, we're not saying that like all of a sudden somebody can't get married anymore, or all of a sudden extra people can get married. We're literally just updating the language. So I don't see why you wouldn't update the language. Like this seems so common sense as far as we've already determined we have a law against polygamy, so it's not going to be multiple people. It's going to be 2 people. Currently, the marriage license sits how the marriage license sits. That would probably change when this comes. But this is an updated language. This is something that we're seeing federally in other states happen. It's unfortunate that the Senate is probably pretty tied up right now, and the senators were not able to come. But this is not something that, it's just not that complicated. So it just isn't.
Representative Gregg, you mentioned that you had not heard that there was anybody who was against same-sex marriage. That is correct. You have not heard that. But we did hear that in our caucus.
We're not debating, though, the Marriage Equality Act. That's already the law of this. You're not going to change that by adjusting this language to the law that has already been passed years ago, 15 years ago. So you're not, somebody might be against that, and that's a matter of their own beliefs. However, that is the law that we have, and that is the standard here in New Hampshire.
And I have heard Republicans argue that against Democrats, and Democrats argue that against Republicans. And in each case, I have heard people say, yes, but I wish to weigh in according to my conscience. Granted what you've said, I've heard you guys do it. I've heard us guys do it. So that would be the basis. No, it does not change the law.
No, and I think maybe I'm speaking for myself then. My basis is if this entire legislative body has passed a law, then that's the law that we respect. So unfortunately, that's what it is. If somebody puts in amendments, then they put in amendments, but that's what we have right now.
Understood. Representative Schultz.
Again, Mr. Chair, I really appreciate that you're letting me be here and then say something instead of sitting here. Is it possible that you, as chair of this committee, could talk to the Secretary of State? Maybe they thought it was a no-brainer of sorts. Maybe I'm wrong. Maybe they had nothing to do with it. I don't live far from here. As a sub, I can happily come back. I feel like maybe that would clear up a lot of the problems if maybe you could talk to our wonderful Secretary of State. Just throwing that out there.
That's a wonderful idea. And the fact is, this committee is going to have to come back again, because we had been told that we were going to vote on a brilliant melding of Senate Bill 72 and House Bill 10. That's their words, not mine. And today we have the utter pleasure of voting on it. That didn't happen after it was scheduled. So we will have to come back to vote on that, and we could postpone this and do that on another occasion. That is a theoretical possibility. Just saying, and willing to hear other thoughts on that as well. Representative Love.
Thank you, Mr. Chairman. Prior to the hearing here, another representative and I were talking about new legislation versus old law, and how the new legislation, if passed, supersedes the old stuff. Would it be that far-fetched for some? I mean, we have some judges that are kind of out there to take a look at this and do like you were worrying about. I don't think it's all that far-fetched.
Let me do a thumb vote. And for those of you who aren't in this committee, that's when we vote, but it doesn't count. So the possibility, it's a theoretical possibility. Do we want to sit on this for a couple weeks and come back, or do we want to deal with it today? If you want to come back, thumbs up. Yeah, and the subs can vote too. You're here. I see 1, 2, 3, 4. Was that a thumb, Representative Gander? It was not a thumb. Okay, a thumb was- All right. All right, one. Thumbs up again, please. Okay, 1, 2, 3, 4, 5, 6, 7, 8. Out of how many in the room? The thumbs have it? That would have to go to a vote. I just wanted to see if that would be our vote. Okay. Okay, the thumbs are gaining. Then this will, let me get the language right. This will end the committee hearing and the exec session will be postponed to a later date. Is that the correct thing?
Yes. And by the way, if I may, Mr. Chairman, I just wanted to correct my former representation. Down at the other side there was correct. It's 457. I said 157. I just had my numbers a little off there. Thanks.
Okay, so this ends the hearing on 269, and we will bring it back to exec after some of us have done some homework. Now, this was supposed to be the happy hour in which we started a torturous discussion on the melding of SB 72, and which is Representative Tim Lang's bill on parental rights in education, which passed the Senate, and House Bill 10, which is the Speaker's bill on parental rights in general. And somehow some people wanted that melded, and it was supposed to be done, and we were supposed to look at it today. And so therefore I was supposed to schedule it, and there we are. So we have 45 minutes until the Chief Administrative Justice, Judge Ellen Christo, will come for an hour. I asked her to come for continuing ed. I also asked her to come because we have retained Representative Bernardi's bill on doing away with family court, et cetera, et cetera. That is why I called him when I knew I'd have at least one vacancy today and said, who better to be here and therefore be able to pepper the judge with questions than the sponsor of the bill we are taking a look at. So what do we do until 11 o'clock? Well, we have additional things about family court. There are a lot of things we cannot do in the next 45 minutes, but one thing we can do is hand out some documents relevant to family court to each one of us. And I would ask you then to, Representative, we have finished our voting session and have no more voting sessions today. But you can come, you can sit in on us. You like to. So there will be packets of material given out to everybody, and I'm going to ask you get yourselves into groups of 3 or 4. That is well under the 91A rule. And go off in a corner, and until about 5 minutes to 11, I'll let you guys plow through the materials. Appoint a secretary, write down some great ideas you have, because this will inform us in our work, initially with the subcommittee on family court, but eventually as we take a look at Representative Bernardi's bill later on. So if Attorney Grant, would you pass out the packets of stuff? And it would be a suggestion that your little groups of 3 or 4 are bipartisan. You don't have to, but I'm just suggesting it might be an advantage to go back and forth. You're rubbing the dirt off them, and, well, you know. I hope you had fun off in your little breakout sessions, and whoever took notes or could reassemble some notes, make a copy, and I'd like to have that so when the subcommittee continues our work, we'll be able to have something from your work product.
I did notes. Am I also the clerk of the subcommittee? Was that?
No, the clerk of the subcommittee is my right hand and arm person.
Unfortunately, the clerk of the subcommittee had pneumonia for like a month, and so
She
missed
did. It
the
was
subcommittee.
breathtaking.
I did
Yeah.
take notes when I was the.
So you can.
So I'm
kind of-
very nervous about taking it over.
We all started somewhere.
All right.
You know, you'll get there. Took me a year to recognize you when you put your hand up. Welcome. Come on up, Judge Christo, and it starts with E, just like her first name. The clerk from Ossipee, did you say?
Thank you. Thank you, Mr. Chairman. So I'm Judge Christo, the administrative judge of the Circuit Court, and with me today is Elaine Lowe, who is our clerk for the Third Circuit Court, which handles the two courthouses of Ossipee and North Conway. And so she's come down to join me today to help talk about process and how cases, what happens in essence with cases before they get to a judge. So, and particularly with regard to self-represented litigants. So when the chairman asked me to come in today, he asked me about a couple of different things. So I'll start with talking about process a little bit at the beginning, and then switch over to, I know he asked me to address House Bill 652 and to talk about that a little bit. That's a bill that you've retained here at the subcommittee. So, and then we're happy to answer any questions as well to help provide any information to the subcommittee. So I'm going to have start off with having our clerk talk a little bit about what happens when litigants, and particularly self-represented litigants, first file a divorce or parenting petition in the court, and what the staff does with them before they ever see a judge.
Good morning. I have the benefit of also being the acting case manager in Conway. So each court location has a case manager. That person is tasked with working with pro se litigants in divorce and parenting cases to help them through the process, help them fill out the necessary forms required to come to an end result. So once a petition is served, when it's a parenting petition or a divorce involving children, the first thing that we schedule with a case manager is first appearance. Those are all done telephonically now with the two parties and the case manager. We go over, I verify the information that we have, contact information that we have in the computer to make sure everything's updated. We inquire as to whether parties have completed the Child Impact Seminar or have at least registered for the Child Impact Seminar. There's a first appearance video that they are provided. I inquire if they've had an opportunity to review that. Then we move on to whether or not they are currently participating in if they have a parenting agreement. If they're following a parenting plan currently, whether they're voluntarily following a child support order. And that leads us to determine what the next step for that particular case is. Most often, those cases are referred to mediation because that's the best first step. We send them to mediation most often. And we can establish a date right then and there. We have the schedules of our mediators. So the people leave first appearance with a mediation date, typically. In those instances where A joint petition has been filed, and the parties simply need help putting their agreement on paper. We schedule a case manager conference. So basically, I schedule an appointment with the two parties. I request that they bring financial affidavits to the case manager conference. We sit down and we put all their agreements on paper. We complete a parenting plan. We complete a child support order if that's necessary for that particular case, and whatever remaining paperwork that the court will need to finalize the parenting case or the divorce. That's basically what a case manager does, is assist the parties so that they can submit all those documents and avoid a hearing. Of course, trials are not always avoidable. So if the parties are in no agreement whatsoever, we would then, from first appearance, schedule a case structuring and temporary hearing. We shoot for within 30 days to get parties in front of a judge sooner rather than later to establish at least a temporary court order. And that's basically what we do for those particular types of cases.
I am a fellow of NCSL in family matters. And so our cohort goes to various places and does things. And that puts me in touch with people from other states doing much the same work. Sure. And I've heard in a few places, not many, but a few, and our committee researcher is tracking a lot of this stuff down, that there are a few states at least where there is a counseling component. That is to say, one or both parties cannot do the best because of other issues. And so since family court is a creation of the legislature, which our Constitution says it can be, we can help remold it, recraft it, and just speculate as to whether you think applied reasonably, a counseling component might help individuals to come to a better place of agreement.
I will defer to Judge Christo.
Yeah. So I would say that where we would employ counseling in our system right now is you need to be in front of a judge first to determine if a judge would order counseling. And typically there needs to be a reason for counseling. And I would say that I want to make sure that there's a distinction made here between what we would consider counseling versus mediation.
Thank you.
So if we're talking counseling as in therapy, that kind of thing, I don't think that would be appropriate necessarily to be ordering until you're in front of a judge and that there's a reason for it. Clearly, in lots of cases, we order some type of counseling depending on what the circumstances are. And we might order one person to be in counseling. We typically are not ordering people to go to counseling together.
No, no.
Anything like that. But, if we see issues that, seem to indicate that that would be helpful, particularly in situations where, the person's behavior might be impacting children. Something like that, we might order counseling as part of that. But there has to be some type of reasoning for that, and that tends to be a judge decision as opposed to something that the staff would identify before they got in front of a judge.
Thank you.
Yeah. So, any other questions about sort of process? Yeah, Representative?
Thank you, Mr. Chairman, and thank you. I do have one quick question. If you could please give us a little info on what a child impact seminar is, and is it mandatory?
Nope. Okay. Okay. So it is mandatory for any litigants that have children and minor children. It is a mandatory part of the process. Both of them are required to to do the program. I believe it's all done by video now, so it's online. And it basically is a seminar to let divorcing parents understand the psychological impacts that divorce has on children and ways to minimize that as they go through the process. Hopefully it's helpful to some people it's not, but it is mandatory. And I also just wanted to mention too that the mediation component that we send people to after they've filed divorce or parenting petitions, if there are minor children involved, that mediation is mandatory. It is voluntary if there are no minor children involved. We still highly recommend it, but it is mandatory if there are minor children involved.
Representative Petrino.
Thank you, Mr. Chairman. Thank you, Your Honor. How would an individual go about requesting of the courts to have some type of counseling or therapy for one of the individuals? Let's say that, one of the parents believes that the other one is unfit for whatever reason, and they believe this person needs some counseling. How do they go about initiating something like that?
Typically, you're going to see that most often in, for instance, in a temporary hearing, or even potentially the final divorce hearing. It could also be brought by motion in front of it. So there's multiple ways you could bring that information in front of a judge, but ultimately it's got to come in front of a judge for a judge to order that. Okay. And then I know there was another question that the chairman asked. It's not exactly related to initial process, but sometimes I guess it could be. And that is that about when there are some corollary cases to the divorce action or the parenting petition, such as DV cases or criminal cases that might impact that. So I'm going to let our Clerk Lowe talk about that a little bit and how the staff brings those issues to the judge's attention.
So when a petition is filed, staff does a name search through our case processing system to determine, if anyone has already filed a divorce or parenting case, so that we don't duplicate filings. And second, to determine if there are any corresponding cases, such as domestic violence cases or criminal protective orders, even other types of family division cases. We cross-reference other family division cases to the marital cases. And we can cross-reference district court cases. If there's a case in Superior Court, we can't cross-reference the two levels of court cases, but we make notations on the file jacket that there is a corresponding case in another court. If, for example, in Conway, if we run a case name and find a domestic violence case, we match it up and bind it up with the marital case so that the judge has all the files that pertain to that family when he or she conducts any hearings on either of those cases. Yeah.
It has been part of the 12 hours of public testimony before the previous special committee and 2 hours of testimony before this committee that we heard from a number of people that one judge did not know. And you can dismiss one as either an accident or something else. But it's more difficult to dismiss a number of people saying there was not that knowledge.
So that sounds like a training issue. We train our staff to do those cross-reference checks. And I think that's just, again, a training issue. And if it can be brought to Judge Christo's attention or something, we can make sure that additional training is conducted.
Would it be possible in a case like that for one of the petitioners to mention it to the judge? Sir, there is a DV case pending.
Absolutely. Yep.
So they're not without recourse.
Absolutely.
Okay.
Yep.
Representative Gregg.
And if, before we get there, if I could just follow up on that as well, that it, in addition to the judges relying on a lot of what the litigants actually tell us in the courtroom, if there were a problem like that, that things were being missed and it looks like it's in one particular court, that litigant or attorney could absolutely approach the clerk of the court as well, to mention that, or could file a complaint with me as the administrative judge. So there are recourses if that is happening somewhere, but it certainly sounds like that might be a training issue if it's happening in one place and not in a lot of places. So.
Representative Gregg.
Thank you, Mr. Chairman. Thank you, Your Honor. And thank you both for being here today and taking time out to help us out. So it would not be uncommon, would it, for a divorce case to start and other cases to start to be filed, like, maybe a criminal case, an abuse case, something? That's not unusual, is it?
It's not.
So that would, after you
Although
do
I
your,
would say that
it can
more
happen.
often than not, if there's a DV and DV related criminal charges involved, that at least anecdotally, what I see more often than not is that the divorce follows that as opposed to, but it is definitely possible for it to be the other way around.
So I just want to, for clarification, I appreciate that. For clarification, there is only one time that you do the cross-reference, and that's at the beginning of the case, or do you continue to do that to look just in case something else, and maybe the person isn't brave enough to say, hey, we've also filed this other case, or this is happening?
So every time a case is entered, that's part of the process. You do a check to make sure that there are no other cases involving those parties. And if there are, then they're cross-referenced at the time that it's discovered.
I need to clarify a word here. Is it done only at the beginning of the process, or is it kept up in case something now surfaces halfway through?
We don't typically, halfway through a case, we would not typically go looking for other cases.
Okay. So if it's not there, de novo, it might not get there.
Right. And I think that's where we're probably relying a little bit more on the litigants or attorneys to tell us as judges that, and by the way, Judge, there is now a criminal action pending as well. And then we can or we're not consolidating it obviously because it's in a different division, but we can then take notice of that as well. So that part is probably not an automatic all the time. So if it's coming up later, we're probably depending a little bit more on the litigants. I will say if it's filed in the same court, like for instance, it's a DV case that's filed after a divorce case is filed, usually our staff is going to pick that up because when the DV case is filed, if it's filed in the same court, they're going to search for any other cases. So they're going to pick up the fact that there's already a divorce case in process.
Follow up.
So I know, thank you, Mr. Chairman, for the follow-up, and thank you for allowing me to follow up. We have a vast number of pro se litigants. Probably I would put it up against any other state for the number of pro se litigants we have here. So a lot of people are filing their own things. Is there anything on the document or when they file that asks them, do you have any other open cases? Or is that ever a question at the beginning so that they maybe are prompted to do something about it?
The domestic violence petition has that question on it. I don't believe any divorce petition has that on there. Although if there are children involved, there is a certification, UCCJEA affidavit that would reference any other cases involving the children. So theoretically, it does ask that question.
Okay, so if you don't, there's no more questions on that, I'm going to switch gears a little bit here and talk about HB 652. So just as a caveat to start with, if the legislature decides that by policy they want to eliminate the family division and change jurisdiction of those cases to the Superior Court, that's obviously a policy decision, of which, as a judge, I would not comment on that as policy. However, what I can do is tell you what the practical impact of that would be. So, first of all, I want to make sure that you understand that the family division, while it does handle all of the divorce and parenting petitions, in addition to that, the case jurisdiction is also child support, minor guardianships, abuse and neglect, adoptions related to abuse and neglect, termination and surrender of parental rights, juvenile delinquency, children in need of services, and domestic violence petitions. So when you're talking about eliminating the family division and moving all of that jurisdiction to Superior Court, you're talking about all of those cases, not just divorce and parenting petitions. And so the reality is, on a very practical level, that it would actually require restructuring the trial courts in New Hampshire if we were to do that. Some impacts of that, the first of which would be that particularly for pro se litigants, but for all litigants, it would make access to justice more difficult geographically. We have 31 courts right now that handle family division. If you moved the jurisdiction to Superior Court, you would be diminishing that down to 11 courts instead of 31. Because it's only one Superior Court per county, with the exception of Hillsborough, which has 2. So it would shrink down to only 11 courts. So instead of going to your local court, you'd have to go to your county courthouse. Judge time, in terms of the numbers of judges that we have to hear these types of cases. The circuit court has 49 full-time judges, and then 23, I'm just going to lump it together as part-time judges. That would include judges that are on senior status, per diem judges, and then judicial referees. So we have 23 of those that we can assign to cases in the circuit court. So that gives us a total of 72 full and part-time judges in the circuit court. The Superior Court has 23 full-time judges and 6 part-time judges for a total of 29. So you'd be shrinking the available judge time from 79 full and part-time judges down to 29. Unless, of course, you're switching judges from circuit court over to Superior Court. But then you are also running into, there's no room for them actually in the Superior Courts, because the Superior Courts are generally full in terms of chambers, in terms of courtrooms, all that kind of stuff. So on a practical level, you would, I guess, potentially make some of the circuit courts Superior Courts. But that would encounter some legislative problems, because the Superior Court is only supposed to have a county-based courthouse. So some logistics issues there. The next issue is that, generally speaking, Superior Court judges are not trained in family court, in family division types of cases. They're not trained in divorce. They're not trained in parenting plans. They're not trained in domestic violence. They're not trained in, petitions. They're not trained in abuse and neglect. These are all things that we spend a pretty significant amount of time training our circuit court judges in. Is it perfect? Of course not. In terms of the judges, and training is always a continual, ongoing thing that we do with our judges. We train by video, and we are constantly doing updating on the new laws and on training. And we have a listserv, which is an email that you may have heard of, that is just between the judges and our staff attorneys, that where judges, when they're not sure about a legal issue, can reach out and get immediate feedback from other judges. So there's a tremendous amount of backup on those kinds of things. And certainly a lot of that is our family law questions that we help each other out on. And then there's also caseload here. Right now, well, before we get to caseload, the other issue is staff. So we have staff in every courthouse that is specifically trained in family cases, both how to process them, and then of course we have our case managers that are specifically geared towards working with litigants, particularly self-represented litigants, to help them through the process. So I don't know whether the idea would be to then switch all of that staff over to Superior Court as well. But again, we run into the logistics of space in our county buildings to do that. And then caseload, basically there's approximately 22,000 cases filed in the family division every year. That seems to run 21, 22, 23. I think at one time it's been as high as 24,000 cases. So, but on average, it's about 22,000 cases involving all of those case types per year. The current Superior Court docket for all of their cases is approximately 22,000 cases a year. So you would be doubling the Superior Court's caseload. So again, I don't know whether it be just moving all the resources in the circuit court over to Superior, or but there's certainly some logistics that are challenging if we were to do that.
You willing to take questions on this part thus far?
Of course.
Okay.
Happy
Do
to.
we have any questions on this second section here? Seeing none at the time, please continue.
Oh,
I
did you have?
Please continue.
Okay. So that's kind of all I had on that.
Okay.
Wanted to just briefly touch on, and I know you heard last week or week before from our Circuit Court Administrator, Heather Culp, on the ADR office. And so I just wanted to follow up that we are typically doing well over 3,000 divorce and parenting cases in mediation through that office. They're arranging, I think the last numbers I have is 2023, because I don't have the 2024 numbers yet, but it was 3,350 cases that were just divorce and parenting that were mediated. I don't keep a record of whether they were successfully mediated or not, but they went to mediation. In addition, we offer mediation in TPRs, which are termination of parental rights. There's mediation involved in that. And neutral case evaluation, which I'm sure you've probably heard about, which we're finding. So the neutral case evaluation, typically we're having retired judges do it. But I will tell you that since we don't, it's becoming more and more popular in divorce cases, that one of the things we're talking about internally as circuit court judges is to train our current circuit court judges and take them off the bench for a week or two every year to do neutral case evaluations, just not in their jurisdiction. So not where they would sit as a judge, so they wouldn't get the case, but that they would go somewhere else. So that would enable us to offer a lot more neutral case evaluation. And we know that if it goes to neutral case evaluation, I think the number is about 50% of them don't go to trial. So that's a really effective type of mediation. But typically it's not done until all the discovery is done. They're kind of almost ready to go to trial. So all of the facts are out on the table, all the financials are done. That's when neutral case evaluation is the most successful.
Do you think this would be some good education for judges to see what's going on at that level below them? By spending a week, a year doing neutral case evaluations?
Yeah, so I think I might reframe your question a little bit about in terms of what's going on below them. I mean, in essence, what it is instead of you're still going in front of a judge, and it's almost like a mini trial, except for instead of you're just presenting your information by offer of proof, and a judge is telling you, okay, here's where if you were taking this to trial, where it is likely to go, so that the litigants are hearing from a judge what the likely outcome or potential outcomes of the case are going to be. And sometimes that's particularly useful. Sometimes the attorneys really want neutral case evaluation because potentially their client is not being reasonable at all. And they can't get them to settle even though they know that it's a decent settlement, but they can't get their client there. That hearing from that neutral arbiter, and it's different than mediation because the mediator's job is to get everybody to come together. A neutral case evaluator is somebody who is giving you information about what likely outcomes are going to be. And that's why, and particularly at that later stage, it's more successful. But typically it's most successful when people are almost ready to go to trial. So all that work is done, and the same information is going to be presented at trial, but through witnesses and through evidence and so forth. But obviously a person who's sitting on neutral case evaluation can't then hear that case for trial. So that's one of the things that we are looking at doing in going forward.
Representative Corzine.
Thank you, Chairman. And thank you for being here to answer our questions.
My pleasure.
So I was knocking a lot of doors in order to get elected. I'm from Berlin, up in the North Country, Coas. And without a doubt, the number one issue that kept coming up was the family court system and DCYF. My husband and I have done have been foster and adoptive parents for 15 years in the state of Mass. And so we do have some knowledge about the area. But continually, people bring up the inconsistent rulings, stuff like that. And knowing that between 2023 and 2024, 12 little ones died, even though they were known to DCYF. That scares me. And that tells me that something isn't right within the system. How we fix it, I'm not sure. But how sure are you, or how confident are you that these judges are getting the full picture before sending a child back to an abusive or neglectful home? How sure are you that you have all the facts you need, and what could we do to rectify that?
Yeah, that is very challenging. First of all, thank you for your being a foster parent. That is an incredibly selfless and beautiful thing to do. So thank you for that. So I will say that, judges are highly reliant on DCYF in abuse, particularly in abuse and neglect types of cases. These are the cases where DCYF is going to get involved. They're typically not involved in a I guess typical parenting or divorce case where there's not an allegation of abuse or neglect. We are highly reliant on them because we as judges cannot go out and do any type of independent research. That actually violates our judicial ethics to do that. So we have to rely on what is being brought to us in the courtroom. I do know DCYF, in terms of I guess, fixing it, people, more DCYF people out there, their caseloads are staggering because there's not enough of them. And so I think that the more, really highly trained DCYF workers that are caseworkers that are out there that can be doing visits to the home, that can be doing more and gathering that accurate information to bring to court is probably the best way that the court can make good decisions. I would say also CASA representatives are a huge piece of this as well, where they can also be enormously effective because where they're having one-on-one interaction with children that DCYF may not be having. DCYF's mandate's a little bit different, right? So they're, whereas a CASA representative, their focus is on the child, period. And so those are some of the types of things where bringing that information into the court is the best way for judges to be able to make really good decisions. You asked me if I'm confident in it. I am confident that DCYF is working as hard as they can to try and bring us accurate information.
Do you also receive information via the Office of the Child Advocate?
So typically not in abuse and neglect cases. I want to say that because that has more of an oversight of what DCYF is doing as opposed to being involved in an actual abuse and neglect case. So I'm just trying to think through my head as to, you know, those are confidential case types. So I'm not even sure while it's going on, the office, I guess maybe they would know about it, but I'm not sure what the procedure is, frankly, in between DCYF and the Office of Child Advocate. I'm not really sure, but I would say typically you're not hearing from them while a case is going on.
Okay, thank you.
Yeah.
Representative Georges.
Thank you, Mr. Chairman. Thank you for coming here. Thank you to come to train us. That's very important. But I think so. I want to just ask you because when the parents go to the divorce, you said there is a mediation and there is a neutral. And when the parents go to the mediation, there is a mediation and then they go to parenting. And what they do with the kids when there is like a managed children, what is the process for the court about the children?
In terms of the parenting plan for the children or in terms of what the children are doing during the divorce process?
Yes, because the parents gonna go to the parenting because they're gonna learn how they're gonna do with the kids. But the kids themselves, because if there is a problem for child advocate, DCYF, they neglect, abusing, all those kids, what is the process for the court to take care of the children? Because when those parents having a problem, that means at the house, the kids, they're not really good.
Yeah.
They have a problem. What the court do for those kids?
Sure. So is a complex answer, a complex question and a complex answer. So it depends. If it is in a what I would refer to as a typical type of divorce case where abuse and neglect is not involved, but nonetheless, the children are suffering. We know that divorce is very difficult on children. You know, their foundation, their structure is breaking up. And in a perfect world, when parents are doing that, they are not arguing and fighting in front of the children. They are reassuring the children of that just because they're not going to be together anymore, that they both still love the children, all, you know, those kinds of things. It is not unusual in divorce cases where, or parenting cases where you can see the children are struggling as a result of that case, where the court will order counseling for the children. That's actually pretty common for the court to order counseling when kids are having a difficult time. And then if we're talking about in an abuse and neglect situation where DCYF becomes involved, that has very strict rules about the process, the actual process itself in terms of when each hearing needs to happen, and the focus on the abuse and neglect case, regardless of the divorce or something like that, is completely focused on the children. And again, not unusual for counseling to be ordered in situations like that. And then DCYF in those situations will also often provide a tremendous amount of resources to the family, whether it's in the home or outside the home, that are geared towards both parenting as well as support for the children.
Yes, thank you, Mr. Chairman. I'm just coming because the children can be because for parents, when the parents go through they have a problem in the house, that can be also neglect and abuse sometimes. And then also when the parents go to the divorce, if they don't send the kids in counseling, the court doesn't do that too. That's where we are having a lot of problem with all those children everywhere.
Yeah. So I would say it's not automatic that the court order counseling for the children, but it is not unusual for us to order children, but counseling, but typically it has to be asked for by one of the litigants. So one of the parents will typically say that they believe the child needs counseling, and at that point we would often order it. But you're right, it doesn't happen automatically from a court perspective.
Representative Love.
Thank you, Mr. Chair. Thank you for taking my question. When you were talking and describing domestic violence and its impact on judicial decisions, I couldn't help but wonder if the accused was convicted or was one of the litigants denied their constitutional rights or due process rights, were they ignored by the family courts? And if it's found that one litigant falsely accused the other, why are perjury charges never brought anymore? I know they were 20 years ago.
So I can't talk about a specific situation, but let me address the perjury part of this for a moment. The reality is if a judge feels that has been perjury in the courtroom, or there's perjury here, we can't bring charges. All we can do is refer that situation out to the county attorney's office. And I will tell you, I know that judges, including myself, have referred cases out to the county attorney's office. At that point, we are no longer, as judges, we are no longer involved in that. The county attorney's office makes the decision. They do the investigation. They make a decision as to whether or not to prosecute for perjury.
Thank you.
Follow up.
One other question. You mentioned DCYF a lot, and it's hard not to link the two together. Okay, family court and DCYF. But I read the original statement of purpose, and it more or less said that they're a social service agency. I don't think they're getting trained in law enforcement, and they seem to be the law enforcement out of the family court. They go in and investigate abuse. Abuse is a crime. Okay, which should be investigated by the police and tried in a criminal court. It doesn't belong in family court whatsoever. What are we doing here? We're having people not qualified to investigate crime, investigating crime.
So I will say that I think that there's two pieces to that. So one is the abuse and neglect piece in terms of the family and parenting part, and determining whether or not we remove a child from the situation, and ultimately can terminate those parental rights. That is civil, that is not a criminal action. However, out of this, there could also be criminal charges, and it's not uncommon for DCYF to be involved and law enforcement to be involved. The two are not mutually exclusive.
Wouldn't it?
You want more?
Yes, please.
Go ahead.
One more. Wouldn't it be better if there's an accusation, a founded accusation, bruises, cuts, what have you, and and a DCYF worker goes in, they immediately call police, and that's the end of their involvement in that part of the case.
Well, I can't tell you whether, from a policy standpoint, whether that would be better or not. What I can tell you is that then I guess that you would be having the police come in to family court on abuse and neglect cases to terminate parental rights, which I'm not sure that police departments are equipped to do that. So I think you need to have both is the answer to that question. You need to have the civil part, the family part, where you're in the abuse and neglect stage or category. But that does not mean you couldn't also have criminal charges based on the same thing. Because it's civil and criminal, and as I said, the two are not mutually exclusive. So you could have a criminal track running at the same time that you have an abuse and neglect track running.
One more.
Wouldn't the answer to that be let the criminal thing let's find out if somebody's guilty or not guilty before we bring it into family court? Because the accusations are always there in many cases that I know I was accused and it was all unfounded. And I know many others, that keep their hands in their pockets while they're being abused and they end up getting abused. Let's have the criminal charges. Let it play out. And then instead of a family court judge making a bad decision based on a false claim.
Well, that would be a policy decision that the legislature can make in terms of who should be investigating those issues and who shouldn't. So, as a judge, it's not really proper for me to comment on a policy thing. But thank you for asking.
Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. I just want to kind of dive into the difference between the purposes between like DCYF civil actions and criminal actions. Because DCYF operates under, and the family court judges, under specific criteria with timelines for reunifying families, whereas criminal is about putting people away, right? So can you talk a little bit about the role of the court system in protecting kids and best interests of kids versus criminal side of things?
Right. So and ultimately, yes, it is the difference between the civil and criminal tracks in the circuit court. So statutorily, the legislature has created a process for abuse and neglect and has adopted the nationwide standards for those cases. And ultimately, regardless of whether there's any criminal action or not, the best interest of the child is the focus of any abuse and neglect case. And that's all statutorily set out by the legislature. And so that is a tract, and that is a process that is well developed, that we have, as a state, adopted the nationwide standards on, so that children are not languishing in the system for years and years and years, which has happened before.
Follow up.
Yeah, let her finish her sentence first.
On the other side of that, the criminal, the district division, the criminal case, as I said, the two are not mutually exclusive. They can be brought on parallel tracks, but that is a different state interest in potentially finding somebody liable and punishing them for the action that they did on a criminal basis. So it has a different focus, I guess, is kind of where I'd fall on that.
Follow up.
Now the follow up. Thank you. Thank you. So can you speak on how, because you said there are national guidelines, can you speak a little bit about federal laws versus state laws when it comes to DCYF and family court? I'm thinking of like the Adoption Safe Families Act. Like, are there federal requirements that states and courts have to follow, or is it kind of we do what we want?
So I would say I believe that the laws governing all of these, particularly abuse and neglect, are state law. There are when I say national standards, these are national standards that have been developed by the experts in this field, that states across the country have adopted, not as law, but as process, to say, okay, that within you know, you're going to have the first hearing within 30 days. You're going to have the next hearing within 30 days after that. You have the adjudicatory, you have the dispositional, you have, you know, and that if these were developed as a result of best practices by the experts around the country, and most states have, if not all states at this point, have adopted those standards, but those are about process, not law, so to speak.
One more.
Okay, last one. Thank you. So on the family court DCYF talking abuse and neglect cases, and I think juvenile justice as well, there are specific timelines that the state has adopted that we follow. Does that translate to criminal court, or just like in a DCYF case, like the parents know that they're going to be in front of a judge within 30 days, right? Or sooner if it's a removal. Are there timelines or guidelines that the criminal court has to follow, or could it be months to years?
Yeah, so the criminal court has different standards. So theirs is about the constitutional right for a speedy trial, period. So the two tracks are not necessarily the same, and nor are we waiting in the abuse and neglect case, for instance, for the criminal case to be resolved. Now, and I do want to mention in this that in these types of situations, the individuals, unless they refuse to, are always going to be represented by attorneys. So you're going to have a court-appointed attorney in a criminal case where there's potential jail time for abuse. You are also going to have an attorney as the parent in the abuse and neglect case. I just want to put that out there so that it's clear that you are represented by counsel in both of those situations. And counsel it's not going to be the same counsel. Yeah, it's not going to. So you have attorneys who specialize in family law who are going to be typically counsel in the abuse and neglect cases. You have more likely than not public defender. If it's a court appointed counsel, you're gonna have a public defender on the criminal case. And they may be advising differently because there's different parameters here, right? So the public defender may wish to delay trial for legal reasons because he believes it's better for the defendant's case. But the abuse and neglect case is going to move forward no matter what, because we've adopted those standards. On the other hand, the public defender could say, no, we want a really speedy trial on this because we want to be able to bring this case to the family court and say, I was acquitted of this. Now, but they're different attorneys, different specialties for those, one criminal, one family law.
Representative Bernardi.
Thank you, Mr. Chairman. So one of the and this is piggybacking off this conversation we've been having here, one of the fundamental reasons for the transfer of the jurisdiction to Superior Court or criminal court as appropriate for delinquency, abuse, domestic violence is because those cases are far more serious than just a divorce where two people have irremediable differences and it can be resolved by mediation, which was the primary thrust of the proposal, adding some higher standards to the qualifications of those mediators. And the rationale for ensuring they went to Superior Court where you had true judges, constitutional judges, as opposed to referees. You look at the qualifications of a referee, experience in family matters, knowledge in family matters, personal maturity, personal qualifications of patience and understanding. Those kinds of qualifications are not, in my mind, relevant to dealing with tough issues like domestic violence and neglect and those kinds of issues. They need to be in front of a true judge where all issues get thrashed out. Can you comment on that philosophy?
I guess I'm trying to understand exactly where you're coming from here. And are you saying that circuit court judges are not true judges, or are you specifically talking about referees
I'm talking
in the
about
circuit court?
referees in the circuit court making these decisions.
So almost all of the referees in the circuit court are retired judges. So they have been judges. So I guess I'm not quite sure. I mean, presumably if they're a retired judge, they've been sitting on the bench for a long time and they may be more qualified than an active judge. So typically we appoint a judge who has turned 70 and wishes to still continue to sit as a referee. But the majority of, certainly the abuse and neglect cases are being heard by active judges, not retired judges. But I guess occasionally there might be some cases that might be held, but they're retired judges, so they're not. I guess I don't understand what.
So it's my understanding.
Follow up, Representative. Go ahead.
Thank you, sir. Thank you, Mr. Chairman. RSA 490D8 lists the qualifications for masters, who are now called referees. And that's the group that I'm concerned with.
So we don't actually have marital masters anymore?
But they were renamed referees.
Right. So we don't actually have, I think there might be one left that sits part-time on a retired status, but all of the other referees that we have now in the circuit court are judges who have turned 70.
So all the judges in family court are true constitutional officers, not on contract, not on 3-year contracts.
Correct.
Thank you.
2 more minutes.
One more question.
Representative Corzine from the North Country.
Thank you, Mr. Chairman. And thank you again for being here and giving us your time. I'm trying to figure out a way to ask this. So in doing my research for this specific bill, HB 652, I learned about the Office of Family Mediation and stuff like that. And I actually looked into 2 other states who are doing this. The 2 I focused on were Ohio and California. And what they're doing is take out all the domestic violence cases or anything with a criminal aspect to it. And they're sending all of the other cases to mediation, kind of getting rid of the family court division. In both Ohio and California, they've had great success with it, even as far as clearing backlogs in order to get more people through the system quicker. They've found that it's much less stress on both parents and children. It's much more cost effective, so that, poverty isn't so much the issue, or having to represent yourself because of economic need isn't that much of an issue. They also do have a strict training program to become a mediator with their own guidelines. Do you foresee that type of thing helping at all here in New Hampshire?
Well, I think anytime you can add more mediation but before cases come in front of a judge, that is always a helpful thing. So never going to say that that's not a good thing. I think it absolutely is. I would love to have the type of financial resources that California and Ohio have to put some of that stuff into place. And to the extent that the legislature wanted to institute an Office of Family Mediation and fund that and do training for mediators and that, I will say we do training for all the mediators who do family. So I just want to make sure you don't think that they're not trained, because they absolutely are. They're not our employees, but they're independent mediators, but they are absolutely trained by us. To the extent the legislature decided they wanted to add more mediation to that, that's, I think, always welcome. I'm not sure eliminating the family division on top necessarily goes hand in hand with that. But certainly, you're never going to hear me say that I'm against the idea of doing more mediation.
One of the difficulties from where I sit is some of the individuals who are demanding all these additional services and things that would help and so on are also the individuals who in another conversation want our budget to go significantly down. And I try to ask them if they see a disconnect, and apparently they cannot. Anyone else? Yes, Representative Georges.
Thank you, Mr. Chairman. Thank you again, please, to come here for my question. I just want to know about the domestic violence, especially for mostly immigrants when they've been arrested. Like there was domestic violence in a house, they arrest like a man, or most I know they arrest the man. And after that, what they do for the men to go back home, or what happened? I don't know what the procedure for.
So,
yeah.
So the procedure in domestic violence is no different for anyone who comes into the court, whether they're immigrant or citizen, anybody. So when you come to the court, you mentioned the immigrant part. Sometimes there are language challenges. We provide a language assistance, either in person, by phone, by video. We're piloting a new project at the moment in one of our courts using tablets to help with language barrier issues. And so every person who comes into the court can file that domestic violence petition. If a final petition is granted, it's granted for a period of 1 year. There are procedures in place that you can ask to have it extended. But in terms of what the court's role in that is, in terms of potential family reunification or something like that, typically when somebody has come in to file that petition, they're given pamphlets or information for a domestic violence shelter or domestic violence services in their community, because that's where potential services are for those issues. I hope that answers your question. I'm not sure whether it does or not, but.
One more.
Yeah.
Thank you. Because I know most of those people, they don't really know the law here. And sometimes they fight just for the small things. But how to bring unified, to do like a,
yeah.
to unify the family, because for the children, sometimes those women, they cannot really raise the kids themselves without the father. But now the father is left in the house. How to help them?
Yeah. So I would say that help is probably not coming through the court system. That help is going to be coming through through counseling or domestic violence shelters or resources in the community. But certainly a lot of cases come to us in the court system because someone has come forward, oftentimes to report abuse to the police. And the police will refer them to the court system and say, you need to go to the court and file a domestic violence petition. So a lot of times that's where it comes from. And a lot of it's education in the community to know that that support is out there and that anyone can avail themselves of it.
Last question, Representative Love.
Thank you, Mr. Chairman, and thank you for taking my question again. Children being probably the most important and most vulnerable part of our society, and and certainly the damage done to kids because of divorce is on the forefront of just about everybody here's mind. I've often wondered that, well, let me back up a little bit. You heard from Representative Corzine how, it's on the forefront of the family court is on the forefront of the people in the North Country's mind. I'll let you know that in Derry, it is also. And, you've heard about the complaints about these mediators and stuff like that. Why not train all judges, which will, if we do pass 652, that'll have to be. But why haven't we trained all judges in family law?
Well, I can tell you that we train all circuit court judges in family law. Superior Court doesn't have any jurisdiction over family law at this point, so you'd have to ask them about their training. But all judges in the circuit court are trained on family law.
And with that, we will come to an end. I promised we'd get you out of here at 12, and we've run 5 minutes over.
Pretty close.
But thank you so much. We know where you can be found and would love to have you come back again. And thank you, Clerk Lowe from the far north, for coming down to be with us today in the Southland. And Judge Christo.
My pleasure.
I will, I got the posted, I will.
Yeah, because I'm running without a